listener production.
A murder, a conviction, and a 20-year fight to clear your name. This is the story of Henry James Keogh. I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. Anna Jane Chaney was born in Adelaide in 1965, the eldest child of a professional couple who valued education and social responsibility. She excelled in secondary school, earning top marks in humanities and sciences, which led to a law scholarship at the University of Adelaide. During her university years, Chaney cultivated both intellectual rigour and a wide social network. She was active in student societies, volunteered with local charities, and travelled extensively to broaden her worldview. After graduation, Chaney embarked on a promising legal career. She joined a mid-sized law firm, quickly earning a reputation for diligence, fairness, and strong advocacy skills. Colleagues often noted her ability to combine professional precision with personal warmth. She maintained close friendships and family connections, balancing work with travel, culture, and social engagement. She eventually worked her way up to be Director of Professional Standards with the Law Society of South Australia. In her late 20s, Chaney met Henry Vincent Keogh, who would later become central to her story. At the time, Keogh was 11 years her senior, working in financial consultancy. He was described as charismatic, socially adept, and ambitious, with a confidence that would charm professional and social circles alike. Their courtship was, by appearances, conventional and socially harmonious. By 1993, they were engaged, and friends assumed the couple's future together was secure. Henry Vincent Keogh was born in Dublin, the eldest of 3 sons of Irish immigrants. His early life was marked by academic achievement and professional ambition. He graduated in commerce and finance, establishing a consultancy career that gave him a comfortable lifestyle, but also exposed him to financial pressures and professional risks. He cultivated a broad social network and was regarded as persuasive and articulate. He was eventually married and had 3 children. At the time, he was working as an insurance broker after having worked as a suburban bank manager. He first met a 24-year-old Chaney at Adelaide's Bull and Bear Bar in 1989. Keogh later left his wife to be with Chaney, and they shared a home she owned in the Adelaide suburbs, the home where she would later die. Keogh's financial pressures would later become central to the Crown's allegation of motive. Keogh had arranged multiple life insurance policies on Chaney's life, some allegedly without her full knowledge. These policies, totaling approximately $1.5 million, became the key financial element in the prosecution's argument that he stood to gain from her death. On the 18th of March 1994, Anna Jane Chaney was found dead in her bathtub at her McGill home. Chaney and Keogh had been out for dinner and drinks. When they returned home, Keogh went to visit his mother while Chaney stayed home complaining of a bad back. Keogh reported returning home that evening to find her unconscious in the bath. He claimed to have attempted resuscitation before contacting emergency services. Paramedics arrived soon after, but were unable to revive her. Police attended the scene almost immediately. There was no sign of forced entry or struggle. The house was orderly, nothing appeared stolen. The scene's lack of visible trauma or forced entry created a challenge for investigators. The death appeared natural or accidental on first impression, yet circumstances warranted a forensic autopsy. The autopsy was conducted by Professor Colin Manock, then South Australia's chief forensic pathologist. Manock concluded Chaney's death resulted from drowning with significant water inhalation. He also identified multiple small bruises on Cheney's lower legs and, crucially, interpreted these as grip marks, suggesting restraint. Manock's assessment became central to the prosecution. He gave evidence that the bruising indicated intentional submersion and control, consistent with an assailant drowning the victim. The bruising, Manock said, was consistent with someone gripping Cheney's legs before pulling them up over their head. The marks indicated someone had turned the struggling victim upside down, forcing her head into the water, drowning her. However, this interpretation was contested in subsequent years, as alternative expert analyses suggested that bruising patterns could arise from post-mortem processes or accidental impacts. And the forensic analysis after the death extended beyond bruising. Investigators collected water samples, examined bath and bathroom surfaces, and analysed fingerprints. No conclusive evidence contradicted Keogh's presence as a caretaker of the body, yet the combination of circumstantial factors, insurance, relationship, and alleged bruising became the cornerstone of the prosecution's narrative. A major component of the Crown's case involved Cheney's life insurance. Keogh had arranged multiple policies, some allegedly without Cheney's knowledge or consent. The total sum, around $1.5 million, was a clear financial incentive. But Keogh argued he'd taken out the policies to keep in contact with the insurance companies in his role as an insurance agent. He feared he'd lose his job in the bank and would have to go back to those companies. The Crown argued that Keogh's financial pressures, coupled with the potential payout, provided a compelling motive for the murder. The defense countered, suggested Cheney's death could have been accidental, caused by fainting, slipping, or a sudden medical event in the bath. Nonetheless, the prosecution framed the scenario as deliberate, connecting insurance incentives with the alleged grip marks observed by Manock. The police investigation included interviewing friends and family, establishing routines, relationships, and potential stressors. Then there was the financial scrutiny, the analysis of Keogh's finances and insurance arrangements. Police continued to follow up on forensic evidence, examination of bruising, water samples, and possible accident scenarios. Investigators faced challenges. The house showed no forced entry, no defensive wounds, and no witnesses. The prosecution's case would rely heavily on circumstantial evidence and Manock's expert testimony. Coming up, the trials and eventual conviction that led to a 20-year fight for justice. The trial commenced in mid-1995 at the Supreme Court of South Australia. The Crown's case combined, firstly, the financial motive based on the life insurance and financial stress. The Crown focused on circumstantial evidence, Keogh's presence at the scene, and his behaviour following Cheney's death. Then there was the forensic evidence, Manock's interpretation of bruising as grip marks, suggesting intentional drowning. The defence argued that Cheney's death was accidental, supported by alternative expert testimony, questioning the reliability of the bruising interpretation. They said there was a lack of direct evidence of assault, and it was possibly or naturally an accidental drowning. And there was also over-reliance on a single forensic expert. Despite the defence's arguments, the jury found the combination of financial motive, opportunity, and forensic interpretation persuasive. Keogh was convicted of murder and sentenced to life imprisonment with a non-parole period of 25 years. Keogh appealed multiple times. Initial appeals were denied. Courts at the time were reluctant to overturn convictions without some sort of procedural error or a manifest insufficiency of evidence. Manock's testimony was treated as credible and authoritative, making it difficult for the defence to argue convincingly against the original verdict. In prison, Keogh and his legal team began assembling evidence challenging Manock's conclusions. Independent pathologists suggested that the bruising patterns could arise post-mortem or from non-violent causes. The drowning scenario described by Manock lacked supporting evidence, and these findings formed the basis for future appeals once legislative reform allowed fresh evidence to be considered. There's a significant twist in this story. Unbeknownst to the jury, Manock was under investigation. The probe began just before Keogh's trial began. The investigation began after Manock attributed the deaths of 3 unrelated individuals to a rare cause, bronchopneumonia, despite the cases being unconnected. South Australian coroner Wayne Chevelle investigated Manock's findings and concluded just days before Keogh's trial that Manock's claims were baseless. It found his answers were misleading and his post-mortem examinations hindered rather than aided investigations. Chevelle's report, highly critical of Manock's credibility, was withheld until after Keogh's trial. The jury were fully unaware of the findings. The jury also was not told Manock lacked formal forensic pathology qualifications. He'd been appointed to a specialist role without proper credentials. The jury was also not told that evidence suggested Anna Chaney's bruises could have been days old. And indeed, they may have been simply caused by everyday activities. There was also evidence the alleged drowning method was physically impossible due to a solid wall at the scene. And in relation to the insurance policies, evidence showed Chaney had full knowledge of at least 2 policies supposedly taken out without her consent. Police later conceded the death scene was not secured and the body was tidied up prior to being removed from the scene. Then there were photographs that indicated a possible severe allergic reaction. Manock had also failed to review Chaney's medical records. All of these significant factors raised concerns for Dr. Robert Moles, Australia's leading expert on miscarriages of justice. He became convinced of Keogh's innocence after reviewing the case. Keogh's very first trial for the murder of Anna Chaney was held in the Supreme Court of South Australia. It ended in a hung jury. The jury was unable to reach a verdict. A subsequent 2-week trial in August 1995 relied heavily on the evidence of Dr. Manock, and Keogh was convicted of murder and sentenced to life imprisonment with a 25-year non-parole period. The trial attracted massive media coverage. A third trial in December 2014 before the South Australian Court of Criminal Appeal dismissed Keogh's conviction. The court cited the miscarriage of justice due to flawed forensic evidence and Dr. Manock's recantation of his earlier testimony. In a stunning twist, a report by the Crown Solicitor's Office surfaced. It had been written in 2004, but only emerged in 2014. It found Chaney's death was most likely to have been an accident. Medical professor Barry Vernon Roberts found Chaney probably slipped, hit her head, and drowned in the bath. That report also found the grip marks, the bruising, to be a false finding by Manock. No one is quite sure to this day how or why that report had not been made available back in 2004 when it was written. Following the quashing of his conviction in 2014, the South Australian Director of Public Prosecutions announced plans for a retrial. However, the retrial was abandoned in 2016 due to the unavailability of a key witness, leading to the case being dropped. In the December 2014 hearing, before the full bench of the Supreme Court of South Australia, the Honourable Justice Thomas Gray, the Honourable Justice John Sulan, and the Honourable Justice Kevin Nicholson considered Keogh's fresh appeal. It considered evidence in relation to Manock's testimony. It considered testimony also given by Professor Derek Pounder, a renowned forensic pathologist, called as an expert witness in the case. He was tasked with reviewing Manock's findings. I'll read directly from the Supreme Court judgment in the words of Justices Gray, Sulan and Nicholson. The following extract from the opinion of Professor Pounder is, in our view, compelling. Observation and recording of the bruises which form the basis of the allegation of a homicidal assault is both deficient and inaccurate. 2 bruises to the back of the head are the result of the autopsy dissection and were not produced in life. There is only one injury to the head, and that injury is to the front of the head and not towards the back, as was presented at trial. The bruise to the front of the scalp is readily explicable by a forwards unprotected fall and not easily reconcilable with the homicidal scenario advanced at trial, which envisaged the deceased on her back in the bath. The erroneous opinion was proffered that the head injury could not have caused unconsciousness, and by inference that a fall with resultant head injury could not account for death by drowning. Bruises to the front of the right shin are typical of those which result from day-to-day living, and there is no objective reason to suggest otherwise. There is no objective evidence, other than the view of the autopsy pathologist, that a lesion to the inner left leg was a bruise, and there is compelling microscopic and photographic evidence that it was not a bruise. It was this lesion which was alleged to be a bruise, representing the thumb mark of a hand grip. 3 bruises to the outer aspect of the left leg, even if regarded as fresh or recent, could have been produced separately at any time within a few days of death as the result of day-to-day living. The opinion that the bruising to the left leg represents a hand grip is a subjective speculation, a personal hunch, and is so poorly founded on fact that, on the now available evidence, it could not withstand critical analysis. In brief, there is nothing in the autopsy findings, as now known as results of disclosure of autopsy photographic and microscopic evidence, to suggest that the death is other than a presumed drowning in the bath following a fall and head injury which rendered this unfortunate woman unconscious. The cause of the fall cannot be known with any certainty because consideration of the possibility of a fall was never seriously entertained, and the opportunities for appropriate investigations have been irretrievably lost. The broad possibilities are that a fall was the accidental result of a concurrence of circumstances, or that there was an underlying occult natural disease. There is nothing in the medical evidence to raise the suggestion that the death was homicidal or to discount the death as being accidental. The following extract from the opinion of Dr. Matthew Lynch, another expert tasked with considering Manock's evidence, is also compelling. A point of critical agreement, in my view, is that Professor Pounder opined that there was no evidence to suggest the death was other than a presumed drowning in the bath following a fall with head injury, rendering the deceased unconscious, and that there was nothing in the medical evidence to raise the suggestion that the death was homicidal or to discount the death being accidental. The judgment goes on. The evidence before this court demonstrates that the trial court and the jury were materially misled in respect of important matters. Material aspects of the evidence of Dr. Manock were incorrect and should not have been led. Dr. Manock, in our view, could not, other than by way of speculation, have advanced his opinion as to the grip to the ankle being the mechanism of death. Dr. Manock should have informed the jury that unconsciousness could not be excluded. We do not accept the submission made by the applicant's counsel that there should be a direction of acquittal. To the contrary, we consider that the non-expert circumstantial evidence, when considered together with the forensic pathology evidence as it is now understood, is such that it would remain open to a properly directed jury to convict. However, we expressly recognized that a properly directed jury may consider that evidence would not be sufficient to establish guilt beyond reasonable doubt. These are truly jury questions, and this judgment should not be taken to express a view on whether the applicant in fact committed the crime with which he was charged. For our part, our review of the material does not establish a case for an acquittal following this appeal. Accordingly, we would set aside the conviction and order a retrial. It is a matter for the director to determine how the matter should proceed. We grant permission to appeal and allow the appeal. We set aside the conviction of Henry Vincent Keogh for the crime of murder. We direct that Henry Vincent Keogh be retried. Keogh never faced court again. The South Australian Director of Public Prosecutions decided not to proceed. The case attracted intense media scrutiny from the outset. The public reaction was mixed. The Crown versus Keogh remains a landmark case in Australian criminal law, illustrating the interplay of forensic evidence, legal procedure, and human judgment. Anna Chaney's death was a profound tragedy, but the legal journey of Henry Keogh underscores the vital importance of due process, critical evaluation of expert evidence, and procedural safeguards in ensuring justice. The case also catalysed ongoing discussions about forensic reliability, appellate rights, and the ethical responsibilities of both legal and scientific professionals. Today, the Crown versus Keogh is studied as a critical example of how the justice system navigates complex, high-stakes, and technically challenging criminal cases. Keogh now lives in Adelaide with his wife. He told the Australian newspaper in 2018 that he is not angry, bitter, or resentful about being convicted. He received $2.57 million in compensation from the South Australian government. Thanks for listening to Crime Insider's Judgments. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at Listener Crime or TikTok at Listener Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound design by Niall Fernandez. This series was recorded and produced on Gadigal land.